Namaste, students. Today's topic is Section 32, Subsection 1 of Indian Evidence Act 1872. This is called Dying Declaration. Very important for your examination. They may ask you a question. Please take the question. What is a dying declaration? Discuss its relevancy. I repeat again. What is a dying declaration? Discuss its relevancy. Indian Evidence Act Section 32 Subclass 1 says as follows. When the statement is made by a person as to the cause of his death or as to any of the circumstances of the transaction which resulted in his death, in cases to which that cause of that person's death comes into question. To analyze, let us analyze in our own simple words. Death can be classified into two kinds. One is natural death. All of you know this. One is natural death and another is unnatural death. Natural death is not a question before the court of law, but the question comes when it is the case of an unnatural death. That means when a person is killed, murdered, assassinated, slain, or lynched by the other persons, then the victim who is still alive, who is approaching his death, he is still in a position to speak. He can explain as to the circumstances which resulting in his death. He can explain the names of those persons who caused him such an injury, such a pain. He can explain the place, the time, the date of the incident. He can explain the reasons or the intentions or the motive for that crime. So, dying declaration means the statement made by a person who is on the verge of death about those persons, those circumstances from which he is going to suffer death. Okay? So, this is dying declaration. Now the question is it very relevant? Is it very, very important? Can it be accepted by the court of law? Yes. Section 32(1) says it is an important piece of evidence. It is a relevant evidence and the law respects. It gives validity to the dying declaration. Why? why the law gives validity to the dying declaration. You know, we the human beings, we always lie. We make false statements. We don't worry about others. We will make the lie. But in only one circumstance, we are all going to tell the truth. That is, when death is approaching us, when we are seeing our own death because of no fault of us, because of the wrongs, because of the crimes of other person on us, then we will not have any hope to live on this earth. We know that we are departing from this earth. There, the nature will make us to tell the truth. So the jury says, truth will play on the tongue of the dying man. Truth will play on the tongue of the dying man. So there is no reason to make any falsehood, any false statement, only the truth. That's why dying declaration is a very, very relevant piece of evidence. Now here the question is, can the victim write the dying declaration on his own? Oh yes. If the victim is still having the strength, he is having an opportunity, he is having a pen and a pencil with him, yes, he can write. He can write, he can explain all the circumstances of his, and he can affix his signature. But this may not be possible in all the circumstances. Sometimes nothing may be available to the victim to write. Then someone may come near him. He may be a family member, he may be a stranger, he may be anyone. They may come near the dying person. Then the victim is going to make the oral statement to that person, and that person may make a statement. Okay, he may write it down and he may take the signature of the dying person, if possible. I'm using the word if possible. Or the other person will listen very carefully all the statements, and he will keep it in memory, and he will reproduce the statement of the dying person either before the police department or before the court as witnesses. So the dying declaration may be in writing or it may be in oral form. Both forms will be accepted by the court as relevant. Okay, so you know dying declaration now, section 32, subclass 1. Here I need to give you some important cases, and you have to write as many cases as possible. Let us take the first case. See the name? Very long name, lengthy name. Pakala Narayana Swami versus Emperor 1939. You know, try to remember in a story form so that you can write in the exam very easily. Story of this case is as follows. There is a district collector. The district collector is having a wife, is having a daughter, and is having a son-in-law in their residence. How many persons totally? The district collector, his wife, daughter and son-in-law, all the four in a beautiful residence bungalow of that DC. In the office, district collector had a office servant. You know, office servant, he may be standing in front of the door waiting for the visitors. Okay, he will always be ready to listen to the DC. So there is a servant. We call him as office servant. Remember, this office servant was not poor. He was sufficiently rich. He was residing in a far-off village. Son-in-law of the DC had the knowledge of the richness of this office servant. Son-in-law of the DC was a useless person, lazy person, having all bad habits. He wanted money, 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 but he was not earning anything. He wanted money. What happened? From the 3-4 years, whenever the son-in-law was in need of money, he used to write a letter. Letter to whom? Letter to the residence of the office servant. In the letter he used to say, please give me this much of money. He used to put all the date and the signature. Office servant, after receiving the letter, he used to collect the money, arrange the money, go to the home of that DC and give the money to the son-in-law, okay, and he used to come back. Like this, the DC son-in-law has taken money for a maximum amount. In those days, 1937, the salary of a DC was 10 rupees. You can imagine. At that time, son-in-law of the DC received more than 3,000 rupees. And today you can imagine what will be the amount. One day what happened? It is this date I'm repeating here, I'm quoting here. 20th March 1937. The office servant received a letter. And in the letter, there was no signature of the son-in-law, but it was the same handwriting. Son-in-law had forgotten, or purposefully he has not written his signature. And in the letter he says, come to my home tomorrow. I am going to clear all your money. That office servant showed the letter to his wife. He told his wife, tomorrow, that is on 21st March, tomorrow I will go to Saheb's residence. I will meet his son-in-law. I will collect the money. We are getting the money back. So he told his wife, tomorrow morning I am going to the residence of the DC. Wife preserved the letter. She has preserved all the letters. Next day, he left the house. That office servant left the house. But he has not returned back to the house. In those days of no communications, the wife approached the police after 2 days. She gave the information. The police started the search. what the police discovered is, in a railway carriage, they found a steel trunk, a very strong steel trunk, and the trunk contained the dead body of a person, a sliced, chopped dead body. Then the police called that lady, that office servant's lady, called, "Can you identify this body?" She was shocked that it was the dead body of her own husband. She recognized the dead body. And the police swing into action. Who might have committed this? Why he has committed this? It is a murder. Cutting into pieces? It is not a suicide. It is definitely a murder. So police came to know the lady has given all the letters to the police department. And in every letter there was a demand for money, loan from the deceased son-in-law. So what happened? They went to the residence of the DC. Police department went to the residence of DC and they made a question. Mr. Son-in-law, when did the servant came to the residence? And he said, yes, 21st March 1937, he came to our residence, and he every once in a while he used to come. So even now he came. He enjoys our food, and he slept in one of the room. That means on 21st night he was there in our residence, and next day, that is 22nd March, he went out of our residence. The police recorded it. See, this question, this case, it comes under even in the confession topic and also dying declaration topic. So what happened? Police started collecting evidences, and the dead body was medically examined, and the medical report says that this body was butchered in the night of 21st March 1937. What the son-in-law has said? 21st March, yes, the servant was in our residence. He slept in some room. And the medical report says killing has taken place in the night of 21st March. When the police started investigating, they found one beautiful evidence. Evidence of an auto rickshaw, in those days an ordinary rickshaw. And the rickshaw driver told the police, "Sir, the son-in-law of DC has given me a trunk, a steel trunk, to be transported to the railway station and to keep the trunk in a carriage." See the valuable evidence, how it shines. Later, one lady, she told the police, "Sir, son-in-law of DC has given me this much of amount of money. I went to the market, I purchased the steel trunk, and I have delivered it to the residence of DC." Wonderful evidence. There, the DC son-in-law, on the night of 21st March, cut the servant into pieces, and the police entered those premises, discovered the blood spots. So here, the case was filed against the son-in-law, that is Mr. Pakala Narayana Swami, and the case trial was conducted. And here the question for our section is, what is dying declaration? The dying declaration is the words of the office servant to his wife. What he told his wife? Oh, my dear wife, I received the letter from the deceased son-in-law, and tomorrow morning I am going there. I will stay in their home tomorrow. 22nd, I will leave their home and I will come back to my home. These words were held as valid dying declaration. The circumstantial evidences proves the killing inside the house of the DC. Son-in-law of the DC has accepted the presence of the servant in the residence. So, dying declaration is accepted along with all other circumstantial evidence, and Pakala Narayana Swami, son-in-law of the DC, was given the death sentence. Okay, so this is one. Don't forget this date. Okay, this date is very important in writing the exam. Okay, another beautiful case. Queen Empress versus Abdullah, 1885. You know, female's life is a painful life. Some females will be very happy. They will spend the time with their husbands. But some females, they have to serve the society as prostitutes. So this is the case of a prostitute. There was a young girl about 18 years of age. Every day she was entertaining some 8-10 customers. There was a big house. It was owned by a lady. She was the master of that brothel. So many persons, male, were visiting the house of the prostitute. It is a life of curse. What happened is, one day, it was morning, there was sufficient light. One customer, in that morning hours, one customer came and he attacked, beaten, and with a razor, he cut off the throat of the lady. And he ran away. He gave a slash here and ran away. Remember here, now she lost her voice box. She cannot speak. She was bleeding. She was taken to the hospital where the magistrate came, the police team came. Magistrate made a plan. How to collect her information. Who has attacked this lady? Who? How he has attacked? Magistrate told the lady, see, I am going to ask questions to you. You simply show the symbol from your hand whether it is right or wrong. Okay, so we will write down the story. They said, what time this happened? Today, morning, 5 o'clock or 6 o'clock? She said, 6 o'clock. So today morning, 6 o'clock. Who entered your room? You know, they had the records of those customers, regular visitors are there. They know the names of those regular customers. The magistrate asked, the brothel owner asked, who entered your room? They had a list. She started reading. Is it Shah Rukh Khan? Is it Salman Khan? Is it Chandravedi? Is it Tripathi? When the name, she said Abdullah, she said yes, Abdullah. So immediately they wrote down Abdullah. Like this, by means of hand movement, the victim started explaining the story of the crime. And the magistrate recorded it. It is as follows. Today at 6 a.m. Abdullah entered my room. He quarrelled with me. He has beaten me, and he took out his knife and cut my throat. The magistrate read over the story and she said, yes, true. She made the sign, true. So they could secure her thumb impression on the statement. As a result, Abdullah was arrested and he was convicted for killing the lady. Okay? So, wonderful writing down of a dying declaration, that is by hand symbols in this case. We'll go to next case. Kushal Rao versus State of Bombay, 1958. Nagpur is an important town in the state of Bombay, or the present state of Maharashtra. In Nagpur, there is an industrial area full of factories and industries. There was a leader, labor leader. His name was Babulal. There was a leader. His name was Babulal. One day, it was night, around 9 o'clock. Babulal was attacked by 4 members. Out of these 4 members, he could collect 2 names. That victim has told the name of Kushal Rao and another man, Telli. Kushal Rao, one person, and another was Telli. As a result, subsequently he passed away. That labor leader died afterwards. He was grievously injured. Then what happened? The case was conducted against Kushal Rao and another, Mr. Telli. The trial was conducted and the dying declaration was accepted in the lower court as valid. But criminal law advocate, they are always interested to save their clients. So they took the benefit here. They said in this case, when it came to the Supreme Court, the name Kushal Rao and Telli is very ordinary name. In an industrial area, you can find so many Kushal Raos and so many Tellis. Then the question is, which is that offender? Who is that exact offender? The identity of the offender cannot be made out properly. There is a doubt in identifying the offenders. So then the Supreme Court said, yes, here is a dying declaration which has not identified the killers. There are so many such persons with such names, so there is doubt. Better not to punish the offenders. And Kushal Rao and Telly were acquitted from the charge of murder of the labor leader. Another case, Somnath versus State of Haryana, 1980. There are loving husbands. There are also husbands who always taunt, ill-treat their wives. Somnath is one such wife ill-treating husband. He was always beating the wife. One day he decided, what kind of useless wife is this? He decided and started beating her, and then he brought kerosene tin and he set the lady on fire. Very simple process. Very simple process. Death is very easy. So what happened? The lady was saved, taken to the hospital by the neighbors. And in the hospital, police, judicial staff, doctors were all present. And they asked, can you make the statement about this incident? She agreed. She was in her sense. She agreed. And she made the statement. She told when the marriage took place, what is the occupation of this man, how he started ill-treating, okay? All these words, step by step, uniformly, she started explaining. She told that yesterday my husband brought kerosene and poured on me and he set me on fire. And she requested in that writing, she added some more words. She requested all the authorities there, please don't punish my husband. Please release him. He must live happily with lot of mental peace. Kindly release him. And after 2-3 hours, she breathed the last. She passed away. The question came before the court. Is it a valid dying declaration? If the dying declaration is valid, it has to be followed completely or not to be followed completely. The accused lawyer, the husband's lawyer, husband was Mr. Somnath. Husband's lawyer took the defense. The defense is, If you are accepting the statement of a dying lady as a valid piece of evidence, then you must accept completely from the point 1 to the last point in the statement. You have to accept, you have to give validity to it. See how the trickery of advocates when they become criminal law advocates. So, Somnath, lawyers wanted to acquit him, but the court said, the judges, some of the judges were finest in India. In this case, the judges said, yes, the last part of the dying declaration, that is the plea of the lady, the plea of the victim to the authorities, please release my husband, don't punish him, he must live happily. These words are the true words of love and affection of a wife towards her husband. So, we cannot give validity to this. It shows how good was she. She was so highest human-hearted personality. And the court, they found Somnath guilty and he was given the conviction. Okay, we will go to another case. Sharda Birdi Chand versus State of Maharashtra, 1984. In our society, marriage is a sacred institution. Marriage is building a new relationship. Marriage is a binding between two families. Marriage is an institution of love, affection, cordiality. In this case, Sharda Birdi Chand is the name of the mother-in-law. She performed the marriage of her son and brought the son-in-law to the home. Sharda, a woman of violence, a sadistic personality, a cruel personality, a personality always taunting, ill-treating the daughter-in-law. Few months from the day of the marriage, daughter-in-law came to know that the husband's family members, especially the mother-in-law, is a very, very cunning personality, dangerous personality. She started writing letters in those days, only letters. She wrote letters to the father, mother, or very close friends as follows. I do not know about my life. I feel that I am not going to live longer. My husband, my husband's mother have an intention to kill me. They want more dowry. And I am not in a position, my family is not in a position to give any dowry. So, they may kill me. My life is in danger. She wrote letters to the closest people. After few weeks, she suffered an unnatural death in the house of the husband. And actually, mother-in-law, Sharda Bherdichan, and other members of the family were arrested by the police on the charge of bride burning, killing the lady. In this case, dying declaration means, the court held, letters written by the victim to the father or to her mother or to close friends, close relatives, which explains the danger to her life. Such letters are considered as a valid piece of evidence of dying declaration. The court accepted the letters, and gradually the court has convicted mother-in-law and other members for killing an innocent girl. Okay, so here I have given you this minimum cases. Okay, so in the exam, dear law students, in the exam you have to write cases. There are hundreds and hundreds of cases. Kindly write this much. Okay, enough for today. Take care.